I would rather like to start with my experience when I left Pakistan in 2007 and I went Australia for my PhD studies. When I landed there, it was a sort of election environment. Very popular, once very popular Australian government of Conservative Party of John Howard. That party was set to lose coming election. And another emerging popular political leader of the Australian Labor Party, Cameron Rudd, who later became the Prime Minister of the Australia. So he was all set to take over. And in this background, I went there and I started following the political debate around elections and themes and which kind of political slogans were particularly contested over there. So one of the very interesting issues which was right in the heart of the political debate at that time, that was about the Bill of Rights. And I was really astonished because when I went there, I was having this mindset and understanding that human rights are so basic, fundamental, and universal in a way that they have already been fully incorporated and implemented and enforced, especially in the legislation, in the domestic laws, and in the constitutional frameworks of countries like Canada, Australia, America, and rest of the European countries. But then I realized that this is something which is very basic, and Australians were still discussing this. And there were very controversial kind of issues and debates. On the one hand, there were people who were writing against the adoption of Bill of Rights, especially in the framework of the Constitution of Australia. And then there was a sort of minority opinion which were advocating for the adoption of the Bill of Rights and incorporating Bill of Rights in the Constitution of Australia. So a comprehensive framework across the Australia instead of sort of domestic, localized, provincial legislation dealing with the Bill of Rights. And then I started following this debate a little bit more and realized that one of the popular Australian newspaper, The Australian, almost every weekend the paper was carrying very strong arguments against the adoption of Bill of Rights. And what was the key argument? The key argument that these international human rights frameworks and instruments, they were largely alien and for Australia because Australian experts and many academicians, they were extending this argument that we were different from the rest of the world in terms of our history, culture, and especially the indigenous population, and we have treated the indigenous population. So if we will adopt this international framework, then there would be deep implications and serious implications for us. And then the stolen generations of the indigenous people and communities, perhaps they would come ahead and they would demand not only just an apology, they would also demand for the justice. And we would be perhaps asked to indemnify whatever we have done historically with them. So that was a very obvious fear, and that's why they were resisting that there should not be a chapter of the fundamental rights in the Constitution of Australia, and they are still successful. Why I am mentioning this? I am mentioning this because sometimes when we discuss the human rights framework and global human rights framework in Pakistan or in countries like Pakistan, sometimes a presumption is attached that these are so universal and so acceptable that across the globe they have been adopted the way they are advocated in Pakistan, which is not a reality. It can be a reality, it can be a valid argument to an extent of certain international instrument, but with regard to certain other international instruments, this is not a reality, and this kind of debate is going on still. Even in countries like Australia and number of other European countries as well, this debate has started and it has triggered now. There are so many other examples of the human rights framework and how they have been reflected in the domestic legislation, but I would conclude this point here and then I would immediately come back to the Pakistan. I can realize and I can see that there are some people who are having a law background, so for them few things would be very obvious, but I think that it would be still useful because this is the first intervention of today's seminar. So it would be still useful to mention some of the very basic and fundamental concepts related to the international human rights law or international law in general, and then its incorporation of international law commitments and obligations into national legislation and domestic legislation. There are primarily two approaches. One approach is when a country signs an international agreement or becomes part of the international treaty and convention, including the human rights instrument, and then ratify that. So automatically it would become available for the domestic use and application and enforcement. This is generally an approach of the continental Europe or civil law tradition countries. The other approach is the dualist approach, which mostly the common law country like us, we adopt. We say that yes, international law is important, but when we go and sign an international treaty, for example, any international convention related to the human rights, and then we come back to our country, ratify this, even after signing and ratification, it is not immediately, automatically, readily available for us or for the domestic courts to apply them. And the only way to make them applicable and enforceable domestically is to translate that into a domestic legislation. So if Pakistan, as a common law country, if Pakistan signs an international convention, ratifies an international convention, and does not make an enabling legislation domestically for years, say for 20 years, so the international convention, even after the ratification of Pakistan, would not be available for the enforcement through the judicial mechanism in Pakistan. And in number of cases, Pakistani courts, Supreme Court and number of other courts, they have actually maintained this position very clearly. This is, and the students of the international law, and we teach this basic concept even in the very first class of the international law, because this is the backbone and basic understanding that international framework is important, but it has got certain limitations. But once you sign an international convention and you ratify and you make domestic legislation and you do domestic legislation, so now it is available, its norms are available through domestic legislation. The courts, what would happen then in that case? A citizen of Pakistan can approach to a court and say that my particular right has been violated under a specific legislation, and the court would enforce that. Even in that particular case, court would not be enforcing an international treaty directly. Court would be enforcing the obligations of the treaty as incorporated and reflected in the domestic legislation. This is very important. And while incorporating and implementing that, if there is some interpretation issue, if some explanation is required, obviously the court can refer that this law has been made to comply with the international obligation of Pakistan related to that particular convention. So in this way, certain conventions can be directly cited by the judicial forums in the form of the precedents, but they would not be directly applicable. The only applicability would be the application of the national legislation, local law. Here comes a point lately. The norms and standards which have been set by those international conventions, particularly related to the human rights, be it about the women's rights, children's rights, or other areas of the human rights. Particularly about this debate and generally about the international law framework, there is an ongoing debate that when these norms, standards, and conventions, and treaties, and protocols, whatever you call and whatever situation is there, when they have been largely framed, who were available and who were participating in the room? This is a very important question. So most of the international law which is right now applicable across the globe, when it has been negotiated, when its basic features and fundamental principles and ground norms were negotiated, most of the developing countries, they were not available they were not sitting in the room. They were not having seat in the room. Even if later on they were provided a sort of representation, so they were transition economies, they were struggling with their post-colonial realities. Their technical expertise, human resource, financial resources were not matching to the extent that their participation was a sort of meaningful participation. So when you have made a norms and standards and you set a standard somewhere at a forum where I was not available, and later on you say that this is a universal standard and it is applicable on you as well. So maybe one fine morning I would accept it, but tomorrow you would again come and say there is another standard. and it is equally applicable on you, I would ask why it is applicable. I was not part of the negotiation. So there is no free consent. There is no discussion. Say, no, this has attained the universal standard. So I would say, okay, let's move with this. I accept this. But if every now and then you would come to me and you will ask me that here is another standard, here is another, this is the first generation right, this is the second generation right, this is the third generation right. So from human rights to political rights to economic rights to gender rights. So if you are expanding it in this way, so, and now I say, okay, I am going to the room and I would negotiate, I would give you a tough time. But the moment I would enter the room and I would try to give you a tough time, I face two problems. The first problem is, the moment I start asking about a very basic and fundamental question, you tell me that these questions have already been settled. Because the framework is universal, we are expanding the framework, so you cannot discuss the fundamentals, because there is a universalism there. So this is the first problem I face. The second problem I face, which is a practical problem, because I have had the opportunity to work a little bit in Geneva as well, to participate in UN organizations. Country like Pakistan, which is a significant country, and we have a Pakistani mission in Geneva dealing with the UN. We have a Pakistani mission in Geneva dealing with the World Trade Organization, another part of the international law, and there are so many other satellite offices are there. When serious kind of negotiations are going on, sometimes people from Islamabad, they also go and participate in week-long meetings, sometimes 10 days meetings of different working groups. The problem is, there are 10 meetings in 10 different rooms going on, and your delegation is comprising of just 2 or 3 people. So the people are running from one room to another room and trying to actually say whatever they are willing to say or they have been instructed to say. But my problem is that I don't have those resources to actually fully participate. Not just the intellectual resources, even basic fundamental resources. And on the other hand, if a delegation is coming from United States with 50 people, along with a number of international non-governmental organizations, and the moment a negotiator is leaving the room, all of them, they are meeting and trying to lobby and influence on the margins of the meeting. So these are the practical realities. Then after all this process and limitations, a new standard emerges and you again tell me that here is a standard, which is a universal standard you are supposed to apply. This is the basic context in which dissatisfaction with this all framework and news and standards is emerging. A number of approaches are nowadays emerging. One of them is third world approaches towards international law, 12. So a lot of experts, and this is not a new approach, it has become an established approach. A lot of people are trying to criticize and to develop a critique of the international law frameworks in different areas and different sectors, particularly in the area of human rights. That there is a third world approach towards international law. We want to see it in a different way. We have different kind of culture, we have different kind of religions, we have different kind of socio-economic context. So you cannot say that certain norms have attained the age of the stage of and the status of the universalism, so I cannot question this because my realities are different. So 12 is one approach, but within 12 there are so many shades. Some people are trying to critique the international law framework from 12 perspective, but by focusing on gender justice, for example. Some are trying to do this from the religious point of view. Some are trying to do this by using, for example, Sharia and Islamic law perspective. So there is a variety and there is a sort of variance within the 12 approach as well. But this approach is important from one perspective, that even if you have an international law commitments, you transform and translate them into a national laws, even then this question that from where these standards have come, and these standards to which extent they are compatible with my local realities, my culture, religion, socio-economic context, and who has actually given this status and who has determined that these international norms have attained a universalism. This is the first thing. The second thing is that even after these kind of criticism, if you accept that international norms are acceptable, they are applicable, but sometimes you sign and you don't ratify, or even if you sign and you ratify but you don't translate into a national obligation because you think that we still don't have resources to comply with the commitments. So it would take certain time, though I have made certain commitments. I have ratified them, but I will make national law after a while, after 5 years, after 10 years, after few years. In country like Pakistan, the whole process of ratification is done through administrative setup. This is the executive domains, this is not legislature's domain. This is another problem. Fortunately, today we are sitting here in the Institute of Policy Studies. Professor Khurshid Sahab Marhoom, he has made a suggestion that the whole process of ratification of the international obligations and conventions and treaties, that should be done through Senate or through the Parliament. Or there should be some kind of involvement of the parliamentary committees in the whole process. So we actually read them. There is a discussion that this is CEDA, for example. We are going to sign it, we are going to ratify this, but what does it mean? To which extent it is compatible with our cultural, socio-economic, religious norms? This kind of discussion has never happened in the Foreign Office. Why? Because this is the executive action which has been done. They have signed, and later on a secretary level person would ratify this, and it would become a treaty obligation for you. So like United States, where the Senate has got a sort of strong ratification powers, so whether the ratification powers should lie with the executive, just with the executive in Pakistan, or there should be an oversight role, or there should be some role of the parliament as well in this. Unfortunately, we could not progress this. This kind of parliamentarians, they don't actually raise this issue anymore. They're least bothered and they're least concerned that international obligations, they become domestic obligations. And they are told that when it would become domestically enforced obligation, we will make a legislation, and for that we will come to you. That's why it is indirectly a ratification by you, which may be true, but which may not be true, because sometimes we make laws or translate international obligations into a domestic legislation through ordinances, especially during the dictatorships, and those ordinances later on en bloc are translated into a national obligations without any discussion. And for that we have seen, for example, international trade law related obligations, which Musharraf era laws related to intellectual property and number of other things due to the obligations of World Trade Organization. Those laws have been made without any discussion because there was no parliament, in the form of ordinances, and later on when there was an LFO, all of them en bloc have been ratified by the parliament without any discussion. So where is the discussion? Where is the parliamentary oversight? So these kind of complex problems and these kind of complex issues are there. Then comes another set of problem. I think Imran Sahib is here. He would also talk about this because I was just reading his topic. But that is an emerging trend in Pakistan, and that is a problematic trend. That is direct application of the international law obligations through courts in Pakistan. That is an emerging trend. It is not a unique trend. It was there earlier on, but it was very sporadic, piecemeal, and very limited. But now we can witness a sort of emerging trend that international conventions are reference to international treaties and conventions, especially in the area of human rights. They are very frequently cited in some judicial decisions and judgments and precedents without making it very clear whether they are part of the domestic laws or they are not part of the domestic, as if they are guiding principles, if not binding principles, and they are the principle to interpret local practices and local laws, which is very alarming from my perspective, which may be very useful in terms of giving a fancy jurisprudence when a judgment comes and you cite CRC, Convention on the Rights of Children, when a judgment comes and you cite CEDA, when a judgment comes and you cite other international human rights convention, and you just reproduce its the contents or its interpretations, are leading international experts assigning certain meanings and interpretation to those international conventions. So if you read it, it's really very fancy. And it has become fancy more for the reason that we have now a trend of recruiting some very talented law clerks in Supreme Court and in high courts who are recent graduates, so they are having good jurisprudential background and of the academic work. So they provide a lot of assistance to his or her lordships And they are now reflecting all that kind of debates and discussions in their judgments, and judgments are containing paragraph and paragraph on these international conventions as if they are guiding principles for the interpretation and for the application and enforcement of the domestic laws, which is an alarming trend. Why? Because for ages we have been told that we are a dualist country. International law obligations are not directly applicable in this country. So instead of CRC, why don't you refer to the relevant law, if at all it is there, in Pakistan? So this is a problem. Instead of CEDA, and recently, I have a list of my judgments, so I don't have time, so I would not go there. But recently, in a judgment, Lordship Justice Mansoor Ali Shah Sahab, what he has done, he has heavily relied upon the CEDA, and not just CEDA, the gender justice notion. And while discussing the notion of gender justice, he has cited some of the international authors. And one of the authors, Simon de Beauvoir, he has referred, is an author who otherwise, not in that particular judgment, he has not referred to that particular, but in one of her books, she writes that the Quran treats women with the most contempt. You are citing someone as the proponent of the gender justice and trying to actually enrich your judgment by citing an author who is having very controversial ideas in a country which is Islamic Republic of Pakistan, and totally ignoring your own previous judgments where you have maintained that under the enforcement of Sharia law, when you are making interpretations, it is binding upon you to assign the meanings and interpretations which are near to the teachings of Quran and Sunnah. This is the obligation of law, and later on this obligation of law has been reflected many a times in the judgment of the higher courts in Pakistan. And it was a departure point because previously, before this law, whenever a judge was interpreting a law and there was a confusion, there was an ambiguity, so judges were referring back to the common law tradition. Okay, legislation is ambiguous. A particular provision of law may have 2 or 3 possible meanings and interpretations. So which interpretation we are going to follow? So at that time, judges were saying we will go to the equity and natural justice principles. And Pakistani courts for a long time, they have actually implemented this. But later on, there was a point of departure. Said that no, first we would not go to the principles of equity and natural justice. We will move back to the principle of Islamic law and Sharia law. And first we will try to understand which meaning and interpretation is so closely associated with the Islamic law, and because this is the Islamic Republic of Pakistan, and we will assign that meaning and that interpretation, and on the basis of that a precedent would be set. But then we see that there are a number of emerging cases from Justice Babar Sattar Sahab, Justice Mansoor Ali Shah Sahab, Justice Aisha Malik, and Justice Mazhar Sahab, and so many other judges as well. I'm just referring to some of the very recent judgments. There's a list of judgments where international instruments are referred as if they are not binding precedents, but they are guiding principles of the interpretation, without realizing this and without making it clear that the international law or treaty law obligations are not and should not be directly made applicable in Pakistan, not just as enforceable standards, but as a interpretation, as the principles of interpretation as well. Because if you are doing this, you are doing something, which is my last point, something departure from dualism to another area or another trend, which is known as diffusion of the international law. And diffusion means that how international law standards are practically made part of the national law without following the formal procedure of the rectification and domestication through national legislation. This is precisely done in these kind of judgments. If this is a new norm, then we should make it very clear by giving a clear that the previous precedents, we are not going to follow those previous precedents, and we are setting a new precedent now. So everyone should know that international law, Pakistan is no more a sort of dualist country. But can we do this? Obviously we can't do this, because our custom, tradition, and the common law legal system and its intricacies does not allow us to do this. This is my basic argument, that while discussing about the rights debate in the local context, it is important that we should realize that which kind of limitations are there, which kind of challenges are there, and the judiciary in Pakistan lately, it is actually trying to follow, if not all judges, many judges who are active in the area of international law they are more inspired from the international law principles, and so which kind of trends are there. And my very last point is, it is not just about the human rights principles or instruments. Even in the area of commercial law, or in the areas not so directly related with the human rights law, this trend is emerging. One of the obvious examples is the focus and emphasis on alternative dispute resolution now by the honorable judges in so many cases, citing the international best practices, international forums, and where Pakistan as such is not a party, or if Pakistan is a party, most of them, they are related to the private international law, which is a weaker part of the international law. Earlier examples were related to the public international law. So in the domain and area of the private international law, this trend and tendency is even rather more glaring and problematic, that the courts in Pakistan and judges are referring very frequently to those forums and obligations and trying to impose those forums and obligations and standards and practices even by doing something which is equivalent to the privatization of justice system, that the judges or the judiciary basically entrusted to dispose of and deal with the disputes of the people. They are trying to tell you that our forum is not appropriate, you rather go at a forum which is a private forum under the private international law arrangement and try to settle down your issues through mediation, arbitration, or international commercial arbitration, because that is something which is very important and that is something which is very speedy. This is really problematic. So the kind of trend that internationalization of the local law on the one hand and privatization of justice system on the other hand, if you combine and club it together, so this trend is rapidly emerging in countries like Pakistan through the instruments of diffusion, which is a departure from our earlier settled position of the dualism. So I think there should be a lot of discussion in Pakistan about this tendency. I'm not essentially suggesting that all this is negative. What I'm trying to suggest is this is a clear departure from our settled position. It has serious implication from interpretation of law's point of view, and it may have certain very positive implication for certain segments of society at the same time. So the discussion and debate on this issue should consider all these aspects, and by engaging all stakeholders, and obviously keeping ourselves within the framework of the Constitution of Pakistan, by reminding ourselves that this is the Islamic Republic of Pakistan. Thank you very much.